This matter is before the court on the defendant's motion relating to temporary matters. Mr. Busher.
Your Honor, I believe the court's in receipt of my motion regarding the temporary matters. I've had a chance to speak with my client prior to the filing and after the filing. Situation here, we have a just over 8-year marriage. We have 3 children, I believe 11, 8, and 3. Maybe off on that. I believe that's correct. Parties were residing together at I don't want to call it a marital home. It wasn't a rental either. It was plaintiff's brother's home, I believe. Improvements were made, adding additional bedrooms, so forth. But at this point, I can't really comment on that. Discovery is due by the 2nd, this upcoming Wednesday. I have not received a domestic relations verified financial form from the plaintiff yet either, but that is not due until Wednesday as well. Ultimately, Your Honor, we have a situation where, my requests are straightforward. The parties are living quite a distance away from each other. The children were historically going to, I believe it's the Penfield School District. My client is looking to have them be allowed or ordered to enroll in the Pinconning School District. My client was the day-to-day primary caregiver of the minor children. Plaintiff has had a history of alcohol abuse. I think it led to the detriment of the marriage. He does not have a driver's license. Interestingly enough, plaintiff indicates that he has 15 or 17 people that can drive him. I've never seen it worded that way, but nonetheless, he's not going to be capable of getting the children to school, from school, or to extracurricular activities without the help of other individuals, and that cannot always be guaranteed. Ultimately, Your Honor, I just spoke with my client. There was, I appreciate the court's patience on this. There was confusion because there is a 1 o'clock or 1:15 status or settlement conference here this afternoon. My client had a little bit of confusion. She has appeared. Upon speaking to my client, she has been indicated by the children, again, 11, 8, and 3, prior to today's proceedings, that dad has told them about this case and has told them that, don't worry, daddy's going to win on Monday. That is a major issue. I'm asking for some temporary orders in place, specifically no abusive or threatening behavior in front of the children. Further, no disparaging comments about either parent in front of the children. Additionally, no discussion of this case in any manner whatsoever. You should never be telling a child that daddy's going to win or mommy's going to win. My client has not discussed this matter. Plaintiff has with the children, and that is not their problem to deal with. Additionally, Your Honor, because school is approaching here shortly, and my client has historically been the day-to-day primary caregiver, she's been responsible for the children's schooling on a regular basis. She has not violated any orders, not that there are really any orders at this point, but has not overstepped her boundaries when discussing this with the minor children. And the fact that plaintiff does not have a driver's license, has multiple OUI convictions. I understand that he may be attempting to get his license back, but there's a lot of stipulations that come with that. AA attendance, substance abuse evaluations, counseling, and I have not seen any indication that he's taken any step whatsoever. So to indicate he's trying to get his license back is fine, but without those extra efforts, which I don't believe he's taken, it's going to be fruitless. I handle those on a regular basis. He's not going to get his license back. But that's neither here nor there. Ultimately, we're asking the court to allow us to, or my client, to enroll the children in Pinconning schools. She is more than capable of being responsible and making sure the children are on time, are not tardy, are at school every day, as she has since the parties separated. The separation was May 19th of this year, Your Honor, 8-year marriage. And she will certainly ensure that they are at school on time, their grades are kept up, and so forth, as she always has. I'm asking the court to take that in consideration, given that it is July 31st and school starting here in 3.5 weeks. Thank you.
Thank you. Mr. Vanderhorst.
Thank you, Your Honor. Parties separated in May of 2023 when the defendant left to move in with her boyfriend that lives 164 miles away from the plaintiff. Prior to defendant moving to Peconic, Michigan, the parties resided in Battle Creek for 5 years. The minor children were enrolled in Penfield until last week, when it's believed that defendant mother unenrolled the children in Penfield schools and enrolled them in the Peconic School District. Penfield schools are set to begin on August 21 of 2023. Parties are currently exercising week on, week off parenting time, exchanging the minor children on Thursdays in Perry, Michigan. Plaintiff father would like that to continue. The children have attended Penfield schools for the last 5 years. The minor children have only attended Penfield schools their entire educational career. Minor child Emma is participating in soccer, and the minor child Hank is signed up to start football. Minor children have friends in the area and do not have any friends in the Peconic area. The plaintiff father can provide a safe and stable environment for the minor children as he has their entire lives. Plaintiff father would like the children to continue with the school they have been attending the last 5 years and continue to reside in the home that they've also been residing in the last 5 years. Plaintiff is concerned where the defendant is living. Is believed she was residing in a home owned by her boyfriend's father. Plaintiff's father is concerned with minor children's living arrangements while in defendant's care, such as being in an overcrowded home. Also, plaintiff believes it to be in the children's best interest to not be exposed to any significant other while the divorce is pending. Plaintiff father works as a carpenter. He does have sufficient childcare and transportation for the minor children. As stated, he does not have a driver's license. He does not drink alcohol, and he has 15 licensed drivers, friends, families, and neighbors that are willing to drive the children to school and any extracurricular activities. A main point is the children ride the bus to school, so that would not be an issue for him getting the children to school. Plaintiff does have concerns about the defendant's marijuana use. He has personal knowledge of her consuming it while the children are in the car. He would like a mutual prohibition ordered that neither party consume alcohol or marijuana while it is their parenting time. Plaintiff believes that defendant was employed at Amsterdam Medical Cannabis and Recreational Weed Dispensary until last week, where he believes she potentially no longer has a job. So defendant is asking for the children to move up to the area where the children have no contact. She has no stable home. It's her boyfriend's father's home, and also the children don't have any friends or activities in the area. So plaintiff father does not see how it's in the children's best interest to order them to an area they're unfamiliar with, where they have stability, friends, and activities in Penfield area. Plaintiff is requesting that he receive physical custody and the parties share joint legal custody. The minor child continued to attend Penfield schools they have for the last 5 years. No alcohol or marijuana provision be ordered. The minor children not be exposed to any significant other while the divorce is pending. Each party pay their own attorney fees with child support paid to plaintiff. Thank you, Your Honor.
So, Mr. Vanderhorst, you said that the parties are meeting in Perry, is that it?
Correct, Your Honor.
Okay. And, Mr. Boucher, is there any problem with continuing them to meet in Perry?
No, and Kristen, did you hear that? Has there been any issue with that exchange in Perry?
No.
No, no issue, Your Honor.
Okay, thank you. Well, the court does note that as set forth in the motion and is the defendant's response, that the children have been with the defendant in this matter since May 19, 2023, before they started alternating parenting time in the summer. What the court is going to do is the court is going to grant temporary custody in this matter to the defendant. Court will order support consistent with the support guidelines. The court would grant to the plaintiff standard parenting time. The parties would continue to meet at Perry at a halfway point. Neither party would consume alcohol, marijuana, or illegal drugs when the children are in their respective care. And the court would order that neither party would discuss the case or any of these proceedings with the children at any time. With that, I'll ask Mr. Boucher if you would prepare that order and submit it under 7-day notice. That will conclude this matter at 9:40 a.m. You're free to go. Have a good day.
Your Honor, can I ask one additional question?
Sure.
When the court says temporary custody, is that physical and legal, or is that?
Yep, I didn't differentiate, so it means total custody at this point.
I will.
Thank you.
Thank you, Your Honor.